Good afternoon to one and all present here. I am Manasi Singh from India and I study at Symbiosis Law School, Hyderabad. I hope everyone is keeping well and safe in these times. Today I present here to speak on data privacy, shedding some light on the GDPR rules of the UK. In today's time, when everything has been shifted to the web space, how we interact, how we work, it's extremely important for us to talk about our data. We hear phrases like data is the new oil or data being the new currency a lot. However, it's extremely important to understand the importance of our data and really start questioning on how secure our data really is. We share so much of our data when we log on to websites and we make payments and we transact documents. And I think it's a matter of deep question to concern, to really question about how secure we are on the web space. In this presentation, we'll be looking at what exactly is data privacy, the intricacies that surround the concept, whether our data really is secure, and why there is an alarming concern around the subject. We'll also understand the GDPR regulations and what role do they play in keeping our data secure and how they protect our data. It will also be very interesting to note on how successful these regulations are going to be in protecting our data. And you can see all this in the slide in front of you. Before we move on, it's very important to understand what exactly is sensitive data. Well, sensitive data is any kind of personal data that you want to enter on any website before you log in. It can be your name, it can be your address, it can be your phone number, or any piece of information that is something very personal to you. Even when you go on certain websites, they use something called as cookies. This is for them to save a certain login. Once you log into the website, cookies then allow you to move from page to page without having to re-log in on every page. Now, there are different kinds of cookies. The concern regarding cookies too was raised once the GDPR was announced in 2018. All of this constitutes as your personal data, any kind of data which you are interacting and using in the web space. As the internet usage has increased over the years, so has the importance of data privacy, as pointed out before. Websites, applications, and social media platforms often need to collect and store these personal data about the users in order to provide services. However, some applications and platforms may exceed the user expectations for data collection and usage, leaving users with lesser privacy than they realized and anticipated. Other apps and platforms will not place adequate safeguards around the data they collect, which can result in a data breach that compromises the user's privacy. Therefore, to come to what data privacy is, data privacy sometimes is also referred to as information privacy. It's an area of data protection that concerns proper handling of data which is sensitive in nature, that includes notably personal data, but also confidential data and certain financial data. As you can see in front of your screens, data privacy is a branch of data management that deals with handling personal data in compliance with data protection laws and regulations. It's also important to understand why addressing the issue of privacy is the need of the hour. Why do we need to talk about it? Well, in many jurisdictions, privacy is often considered as a fundamental right, a human right, and data protection laws hence exist to guard this right. Data privacy is also important because in order for the individuals to be willing to engage online, they have to trust that their personal data will be handled with care. Organizations use data protection practices to demonstrate to their customers and users that they can be trusted with this personal data. Personal data can be misused in a number of ways if it's not kept private or even if people don't have the ability to control how their information is being used. Criminals can use this personal data to defraud and harass the users. Entities may sell this personal data to advertisers or any other third party outside without the user's consent, which can result in users receiving any unwanted marketing, advertising, or just the outcomes being extremely detrimental to the individuals. The outcomes for such breaches also are extremely detrimental to businesses as it causes an irreparable harm to their reputation, which results in them paying heavy fines, heavy sanctions, and even dealing with legal consequences. And because of the aforementioned reasons, we need a strong data protection legislation in place that is structured, that helps us in preventing such breaches that can be detrimental to so many parties, right? Hence, the General Data Protection Regulation was enacted. This regulation is the toughest privacy and security law in the world. Though it was drafted and passed by the European Union, it imposes obligations onto organizations everywhere so long as they target to collect data related to people in the EU. The regulations was put into effect on May 25th of 2018, and these rules, they levy harsh fines against those who are going to be violating the privacy and the security standards, with a lot of penalties that cost up to millions of euros. As we saw before, and as what we're discussing now, is that GDPR is one of the biggest as well as one of the most important data privacy regulations that have come up in the past 20 years. It can also be considered as a major turning point in the data security narrative. This new regime has been formulated specifically to transmute and change the way in which organizations deal with personal data, and this will be by prioritizing the consumer's data and them being in control of their own data. This also marks the first time in which the consumers have power over controlling their own personal data, which implies what they intend to share and what not. As I've extending the point that I was just talking about, accountability. GDPR says that the data controllers have to be able to demonstrate that they are in compliance with these regulations, and this is not something that can be done away with without showing any substantial proof. And the proof that the company is being in compliance with the regulations is that they have to designate a data protection responsibilities to their own team, to also maintain a detailed documentation about the data that they're collecting, how it's being stored, how it's being used, and what employees are being responsible for it. Also, a properly trained staff and them implementing proper technical and organizational security measures. Moreover, a proper data processing agreement contracts have to be in place with the third parties if the contract is to process data for you. There are about 7 principles that the GDPR talks about, and the key principles are: first one is, as you can see on your screens, lawfulness, fairness, and transparency. Any processing of the data must be carried out in a very lawful, fair, and a transparent manner. Purpose limitation. The data must be processed for legitimate purposes only, and that has to be specified explicitly to the consumer. Data minimalism. The only data is to be collected and processed which is of absolute necessity, and no more than what is necessary. Accuracy. The personal data must be kept up to date and must be accurately stored. Moreover, storage limitation. The only data that can be stored personally, it is only for the purpose as long as it has been specified. Integrity and confidentiality. Any kind of processing of the data, it has to be done in such a way that it ensures appropriate security, integrity, and confidentiality in the process. For example, by companies implementing the end-to-end encryption, this gives a certain trust into the platform that the consumers are using. As we talked about this point earlier in the previous PPT, was accountability. The data controller is responsible for being able to demonstrate the GDPR compliance with all the principles. Certain aspects that GDPR brought to the corporates was, first is cybersecurity. As you can see, that certain technical measures were undertaken by the companies. That can mean anything from requiring the employees to use a two-factor authentication on accounts where personal data are stored to contracting with cloud providers that use end-to-end encryption. Also, organizational measures were undertaken by so many companies, such as staff trainings, additional data privacy policy in places, and they were given to the employees as a handbook. and limiting any access to personal data and only to those employees in the organizations who really need to access. Moreover, these regulations have somewhat gone a step ahead in protecting the reputation of the corporations that have incorporated such practices. It gives an edge in terms of integrity and accountability and confidentiality, and it helps the consumers trust the organization more with their data. However, it's important to note these key aspects with regard to the GDPR, and they are that, as you can see on your screens, penalties with regard to the non-compliance of these regulations. Well, with respect to the cost of the non-compliance, it's certainly one that has encouraged these organizations to really put these responsibilities inside the systems. Really, the implementation has been really strong with respect to the compliance since the penalties are so heavy. The penalties can go up to about 20 million euros or even 4% of the annual global turnover and the cost of the non-compliance, and this results of an audit, and this can present a really frightening realization of business's closure if the organization fails to protect their consumer data, and the corporations hence shall be fined. And with respect to cost of the compliances, when the news had first broken out about GDPR that it would be implemented in 2018, most of the organizations had reacted by instating a certain data protection officer to take responsibility for ensuring the internal policies were updated and if there's any kind of required processes that were to be implemented. With regard to depending on any quantity of EU citizen data being processed by an organization, this cost in itself is a lot. But however, GDPR again holds extremely strong positive implications for both businesses and the users, and the cost can be adjusted and it won't really pose a problem. All in all, it is safe to conclude that the regulation is in favor of the consumers, and it also is going to be extremely helpful in keeping the digital space more safer and more secure for all the consumers who are browsing the web space and providing these information to the organizations. Again, as mentioned before, since these regulations were made keeping in mind the keeping in mind the interests of the consumers, this is going to be upholding the right of privacy of all the data subjects who browse the internet. And now I would like to conclude my presentation with this quote by Miss Catherine Neville, who said that privacy, like eating and breathing, is one of life's basic requirements. We should all be mindful of the data that we carry, that we hold, and the importance that it has, and what we share on the web space and to organizations. Now, with GDPR regulations in place, it is where we now have the opportunity as consumers to be very mindful of what we intend to share, what we not, and what we give consent to and what we don't give consent to. And it's very important that that we treat right to privacy as a human right, and we take care of this aspect of our lives as well. And with this, I would like to conclude my presentation. Thank you so much for listening to my presentation. I hope I was clear. I hope I covered all the subjects and all the topics. If there are any doubts, any questions, please feel free to reach out to me. And I hope that I was able to make some difference and give some clarity on my topic. Thank you so much.